Say after me, sir. I solemnly swear that the evidence I shall give, shall be the truth, the whole truth, and nothing but the truth, So help me God, so help I Jah. So help me God, so help I Jah. So help me God, so help I Jah, Rastafari.
Every time I see the wicked, when he moves.
You are brought before this court for having ganja in your possession. Guilty or not guilty? Not guilty, Your Honor. How could one man do such a thing? Ganja. It is totally impossible, Your Honor.
I can remember, yeah, when I was framed and jailed, brutalized. The grudge would find me guilty for an exhibit they could not find. And every time I see a Babylon, my blood runs cold.
Because remember, certain time from now, Court Ose will come to you, the program can come to you from 98.1 FM, the true voice of the people.
The wicked man, I believe move. When I see the condition, yeah, I said it's a curse. For the past 400 years or more, things get from bad to worst. And every time I see Babylon, my blood runs cold. I mean, so cold. And every time I see them wicked men, my belly move.
For news, views, and entertainment, stay tuned to Society for Radio Democracy, 98.1, simply the best.
Yes, Fambulen, good afternoon and welcome to the program Court Ose, where they come to you from the Society for Radio Democracy, 98.1 FM. Court Ose na 2 hours, na 1 hour program where they come to you, and now from 5 to 6, they look at different aspects of the law where Fambulen for know, but we know they give legal advice. They just they look at the law, which in Fambulen need for know the basic things them. Not to way person get matter from probably get matter before the court. The you want for ask the lawyer at the studio not go answer that question there. And you can only ask question or send text message to the number 077981981. But now waiting with the discuss now in you they send you question to. Now they call, you ask question which you don't understand to the lawyer. Well, I get the lawyer way na Paul Kamara, way na lecturer na the University of McKinney, and we don't get here for the second time now. Paul, good afternoon and welcome to the program.
Yes, Mrs. Mange, good afternoon, and Fambul, Kushi and Kabo.
Okay, so we topic today we will deal with now the importance of the role and importance of law of property. So they look at the law of property. Family remember say the edition we been get before this one. We get tenancy. You know, I think family will learn a lot from her. So today we look at the law of property. What in the law say? Yeah, how you they get property, all that kind of thing. How you protect the property, then kind thing then they now in we they can look at today. I get as I tell you earlier, I get the lawyer we now a lecturer at the University of McKinney. Once more, good afternoon and welcome to the program. Good afternoon and welcome to the program.
Yes, Simange, thank you very much.
Okay, so people in good on the law of property, the law of property, the law of property. Waiting at the law of property.
Basically, to start with, the law of property. In law, we get different types of properties first. We get intellectual property law, then the law of real property. So if you just say law of property, it's very generic. But for the purpose of the discussion, we will limit them to the law of real property. Owing to the fact, say, the law of real property, this is not the law or the laws where they govern both the way they acquire and the way also where they use land na Sierra Leone, either by way of lease, by way of purchase, where most people can say by way of sale, or by way of adverse possession. So these are the different ways and way the different areas and way the law of property they cover. And also we can hear about the issue of tenant-landlord relationship, where most of the time we can call tenancy relationship, and the issue of leasehold, who I already don't make mention of, where concerns basically the manner in which basically that's an advanced version of tenancy, where also instead of another form of tenancy, leasehold, where basically they involve both the lessor and the lessee. They come together for make the express interest. The one person they get legal interest, when are the lessor, then the beneficial interest they go to the lessee, where go say within a particular time where they go determine, it will say 15 years, 20 years, 10 years, 5 years, as the case may be. Say I want for all this property with the beneficial interest and you own the legal interest. So these are the different areas when we talk about law of property in Sierra Leone, specifically real property.
Okay, so you don't you don't narrow one down to real property, and from within you don't able for distinguish them. You don't talk about leasehold, you don't talk about freehold, etc., etc. So within a freehold.
Well, basically, freehold in Sierra Leone, the church and concerned the manner in which you they acquire property in Sierra Leone. And so the issue of freehold, now one of the oldest ways and way people be done the old property, either on a permanent basis or on a basis where once you express an interest in the acquisition of that property, you don't get a lifetime interest in them, or some people can call absolute in possession. Once you don't get this forever and ever for your entire lifetime, as opposed to leasehold, where leasehold are just for a specific period of time where they enjoy that property day, and you go into an agreement with someone where get the legal interest for the property within a defined or determined time frame. You they in possession, and thereafter the property they get a reversionary interest, and this reversionary interest simply means they go back to the original, to the estate of the original owner. If you don't die, they go to the estate of that person, who then can say the estate of the deceased. So always they get a reversionary interest insofar as that discussion they concern.
Okay, so you talk about two things: equitable and legal interest. For make it simple for family, may they able to understand that.
So you when you name the date at the document, now you get the legal interest in the property. For example, property of Abu Sise, property of Paul Kamara, where send a signal saying that you are the owner, or basically like okay, say you are the owner of the property, that you get the legal interest. For the issue of equitable or beneficial interest, these are people and where they acquire interest from the person we get legal interest. So for equitable interest, if you go into a tenancy agreement with the person, let's say for a period of 1 year, within that period, you will get an uninterrupted enjoyment of that property day. And in enjoying that property day, you will not face any challenge with respect to both the implied and express covenants when it comes to that tenancy agreement day. For example, the rights for peaceful enjoyment, the rights for let you did without any trespasser or anybody will come and can't interrupt you, say this property, you know, for there, or sometimes somebody go just come and tell you, say, what you cook today, one for no as the owners them, no, you not gonna right today, or for let you just come, this is my own property, I can't check today, I wanna sleep now this also, I can't check today for a sweep here. So because the person get equitable interest, the law they prevent you not for make you they interrupt the daily activities of the person until the effluxion or the elapsing of that term day where you don't go rent the property. But other than that, you don't get any right for make you put on in property.
So if I want for acquire property, I want for acquire land, I want for acquire house. So waiting I need, waiting are the requirements then?
Well, it depends. If you want for acquire property in the western area, in procedure different from the procedure in the provinces. Let's not forget this alone, get a dualistic system of legal system where for the western area it largely governed by the common law, whilst for the cost for upline what we can call the provinces it largely governed by customary law, where some can say the law of tradition. But the most important thing where we need for note now the fact say the issue of acquiring or accusation of property in the western area at times it differs from waiting the happen at the provinces. For example, the provinces now they don't get the Customary Land Rights Act. And that Customary Land Rights Act will tell you say if you want to go acquire property at the provinces, you know, for Freetown before this term, issue of communal ownership will not be there. There'll be individual land ownership. Paul owning property, maybe use them at some point, ready for sell his property. Yeah. But in the provinces, most of the time they will tell you say not to post get property, at the chief get property, where then be they say now the custodians of the property, custodians them, the paramount chiefs them. You know say Freetown no get the Western area no get paramount chieftaincy business. So what thing be they obtain at the provinces and that if you want to go acquire property, you get for pass through the chief, the paramount chief, and then whosoever get the legal interest now. Instead they sell them, that make even when they do conveyance, you always the state and they always you get the council, the chiefdom council committee where always they get approval after we the vendor and you they go buy you the purchaser and don't go into the different agreements, the recitals, the addendum, all then close they were very technical and don't look into them. Then the chief gets side with the sign. But now, because of this Customary Land Rights Act, one way they acquire property in the provinces, first, you get forget family consent if not communal owned property. You forget about not less than 60% of the people who did the consent. You do them in writing. After we don't do that in writing, making always the advice people say based on the registration of instruments or registration of legal documents in a Sierra Leone, I can always advise that any document you do concerning the sale of land according to the statute of frauds, I think section 4, say for reduce them into writing. So then oral agreements and where someone will just come, I want you land, okay, how much 5 leons, 10 leons on a part company. That one is not correct. So according to the statute of fraud, say every transaction will concern land na Sierra Leone for be reduced into writing. So now that can make most of the time lawyers and can advise say let people who they buy land do sale of land agreements. Where you do not sale of land agreements, you register them. Remember saying a registrable instrument, because if you not register them, you know will get na legal effect we supposed to get. It can be a document that could have been concocted, a document that could have been tampered with. But for let you save your interest, please, the advisor to always talk to your lawyer. And not say financial obligations them always involved. But again, we get for the guide yourself wisely. For me, I prefer for put me money to put me money on side and not get safety. But with the sale of land agreement, you are sure. And thereafter, we don't do the sale of land agreement, then go for go do survey. The survey. When they do the survey, if in an upline, then get what they call the director level and the community level. So 2 documents they come out for you for the same land. Where then documents and they come out. If you still want for do the needful, you can do a conveyance. Do the conveyance also and get the same legal effect. But what largely becomes unclear are the fact say most people is either because of lack of knowledge or understanding, then can always feel say then can get rights for make for themselves agreements. See people can go into agreements, say now you go chat GTP, you say please prepare me a sale of land agreement, you will give one kind come sale of land agreement. You see people in print time saying that this agreement mean this person don't go into. No, as lawyers we are very much professional, and now then we go to college for land, and so whatsoever agreement we do, I always advise people solicit the service of a lawyer for let your interest be secured. So once you don't do the sale of land, you get the survey plan where involve your name on it. That is the property don't be transferred in your name officially, and thereafter now you own document where you come out, you go get LS number, a land survey number. If na upline, if na McKinney, they get MLS number. If na put local, you get PLS number, put local land survey number, or if na Bo, they get I think BLS number. So all the areas they are, so then survey plan there, then LS number, then they use like your own identification number. In the event until one goes do search now about the Ministry of Lands. Now just like for conveyance, we always you get now volume and page number at the back of the document. Now one day again now for ensure say maybe if you lost the document, you can go for a certified true copy if you know na LS number. So always try for know na your LS number, because now one day we will protect you in the circumstance until you was born, you lost your document. You can go apply at the ministry, and the ministry will ask you get LS number, and LS number you will show them, and then try for recover your document for you. And a number now one day no they duplicate them. No they duplicate. If you see 2 documents we get same LS number na fake, one part them must be seen a fake on a duplicate of the other. So now then ways they also they acquire property.
Okay, so you talk about the provinces that you get forget 2 documents. You get forget one winner at community level, you get the other one winner at director level. So what are the reason for that?
Well, like I rightly suggest, Sierra Leone is a place where we get a very rich historical perspective. For upline, for the community level, you still get the chiefs. For example, any Sierra land in an upline, you get the section and you get the chiefdom. So side a day for let the section chief sign, Side they for let the paramount chief with the Edna chiefdom they sign. Then side they also, if now within a particular locality, for example, upline, some side and they will the landed day, now within the city council. And the city council, say upline and gets two, then get the city council and get the district council. So if you land it outside the precinct or the demarcation we then give for the city, we sign for stop or we sign for end, beyond there na the district council. So provision the day for the district council chairman or CA, since the chief administrators and administrative people not too political, not did as a result of politics, not vote for them. So the administrative head at times that the name then keep the chief administrator. But in the event the chief administrator not there, and deputy can sign. And in rare circumstances, we can see the chairman then can sign as well as the mayor them they can sign per the document and and also provision can always there for the what they sell when at the vendor for let himself sign, because now when he sign they get legal efficacy. And side they also for let witnesses and sign, the one that will witness the transaction they sign, the append and signature them for sure say yes we actually witnessed. And now the other interesting thing is most of the time when they go do conveyance like for the provinces, the paramount chiefs and can sign if you know we don't do na local. Now locally now they able give the assurance say okay this conveyance what they can sign. If you don't come before me, so the first watch the signature what they give na your own signature. If not in signature they ask you, they put it to strict proof for actually show say if you don't buy this property and that, then correct for let them sign them. But where they go register the conveyance, we see most of the time the administrator and registrar general office they look at na the directors level, because at the directors level then can always give returns for. If you go do conveyance, the returns no dey, certainly the registration of that document could be largely questioned.
Okay, so you get some people probably at the Western World District, now that community level, now that document they can get, and then say they don't get documents. That document the authentic.
Which one?
Like probably the Western area for World District, where now one the community level probably say the man design, the possibly vendor do always sell, probably the council sign on that, and then kind of thing. Then they don't get that director level. Is that land? Is that document authentic? Considering the fact they not get director level, then now only one side.
In Ceylon, we get what they call the Registration of Instrument Act, Cap 256, and get Cap 255 back. 255 indirectly they affect documents away and deposits at the Registrar and Administrator General, and 256 I think provide for general registration. So if you just want to rely on the local, it's very risky, owing to the fact that not a registered document, and if not a registered document you want for exclusively rely on them, it's risky. I can always tell people it's very risky. Now government they try to reclaim state-owned land them, so most of them Western area rural land them and get issues that make the director as I speak, most of them areas, for example in McDonald, most of the sensitive areas in our Western area, rural, not they signing documents them. Why? Because people can, well, there are allegations say people in the way can go take land them when a state and go sell them, and it go be so disturbing for let you see the Ministry of Land on sign per document later then go say na government's property or state's property. It can really raise some, very difficult situations. And it can also create unnecessary burden on government, because at the end of the day, government get for compensate in the event they want to go reclaim. And now one day, if they don't do due diligence, I think that make the director now know they sign any kind of document where they come on their areas and they. But I want to say, based on the Registration of Instrument Act, it talks say any instrument where you do concerning land, you have to register it. Whether it is a sale of land, whether it is a conveyance, whether it is a survey plan, you have to register it. You register your interest. You register your well, basically you go register, say if the issue of title to land come into play, you go tend for protect your own side by relying on the fact that you have a registered document. But again, now one day na a legal argument altogether. Some people can argue, say you only registered your interest and you don't register your title, or you don't register the title, you only register your instrument. That is very legal, highly legal. Now Sidmon Wilson and Abel's case established so many principles concerning title to land, both na the provinces and na the western area. And one for I wish for advise people and say it's very risky that you rely on the headman in your own documents where they just give you. However, if you think say the headman now area they do the director's level, you can talk to your lawyer when I do sale of land agreement. I think in extreme circumstances, the sale of land go able come in for sure, say yes, actually there was an intention to sell the property, and that you've sold the property and now the property don't day now another person, and that if the property not encumbered in any ways, sometimes not to state land, sometimes not to person property, you go grab, sometimes you just go grab this property, and the principle of adverse possession or renting and they come into play. Then later then go find out say the person not be permanently abandoning property. Then now you want to go express or exact interest as if now you own property. That by itself is also very risky. So then can normally advise people and say then document and they not to rely on them. If I will give you an advice, not to rely on them. Rely on the documents where they come over on the ministry. Even with most silence they can cause problem for ourselves. You they see people they get them documenting, okay, even get them for go verify na the ministry for know if the documents na LS number where they can put. It go shock you for I don't do so many conveyance way at the level of registration we can realize the document fake. Just now the office of the registrar and the administrator general in the office, you go no see the document fake. That's also there is serious financial implications, legal concerns, and the likes.
Okay, so with the kind of probably we'll talk about due diligence when we come to that day. But when we look at the provinces, you talk about communal ownership, you talk about individual ownership, and
family.
And you talk about family. So when we begin to take them one by one, when we take family.
Most of the properties now the provinces, these are property then we family members they can inherit. Either from the grandparents, from their papa them, their mama them, as the case may be. So this property not to one person gets them. Now the Kamara family, for example, or the Sise family. And these are a property that way most of the time are virgin property them. Vast land, and you're not you don't share them property or shape them property then. So if you want to acquire them property then you need to get the consent of family members them. You need just go buy the property from one or two family members, knowing fully well so not to then get them, no more. All the other people then get interest on that property, beneficial interest, especially so if they inherit them. So if you go deal with one or two people that will not amount to now 60 or 70% threshold, then you the risky money. In law we call on one day volatile non-fitting GF, for example. You saw the risk and you took it. So it is like you are assuming the risk. That by itself is very risky. So I can, in that kind of situation, I would advise that if you want to go do buy property, always do due diligence. talk to your lawyer, investigate the good root of title for know how they get this property, who they get this property from, who they are the head of the family. They don't administer the estate of the deceased who began a property. They all in question they need to ask.
But if we look at the provinces, then we will get for like administration of estates are in the admin. Well, because they don't get document to the effect. Probably you can get somebody when at the head they say, well, the Kama family this land all left as the head.
Well, the truth is
the responsibility.
The truth is Section 21 of the Court Act of 1965 and also Section 15 of the Local Court Act 2011. Then two law there so then provide say administration of estate of the property of a deceased na local court na aim for duam and it gets in procedures altogether.
Okay. Yes, we because the next question, but okay, more done with Andy. So if me, you don't talk say now only the local courts, probably if not the federal title, not the western, not the provinces, as you say, as provided by Section 21 of the Local Court Act.
15, yes. Section 15 of the Local Court Act.
No, so
Section 21 of the Court Act.
Of the Court Act, sorry, Section 21 and Section 15 of the Local Court Act. You say the side way for go na the local courts.
Yeah.
So if I get land because I know say me a lawyer probably I not get audience. There are file papers there. I go to the High Court or I go to the Magistrate Court. I left the local courts as provided by Section 21 and 15. So then they go nullify the proceedings, for say, okay, you not get that right, you not get the jurisdiction for doing.
Well, the truth is, if a lawyer attempts, I don't make so many applications where I succeed for raise jurisdictional objection, where somebody they go commence an action where concerns title to land. Now the High Court, land we governed by customary law. In that kind of situation, the other side could just raise an objection, say you're not supposed to. So normally, if not upline, then can start na the local court. Now then call the court of first instance as far as the issue of title to land and administration of estate concern. So you will start na the local court, and thereafter, if the decision turn otherwise, you can appeal at the district appeals court. And if the decision still not okay, you can go to the High Court. But then when they go to the High Court, there is a special division of the High Court where they go to. And call on the local appeals division of the High Court. Section 40 of the Local Court Act established now one day. That court in all the free town, in all the western area, all in the provinces it dey for property we govern and we govern by customary law.
Okay, and I think when they go for break, we hold you the back way, we come, we will continue with the other section and with the other discussion, the other areas then also we will give the opportunity for more people call and ask questions. So wait till we discuss now.
Say after me, sir. I solemnly swear that the evidence I shall give, shall be the truth, the whole truth, and nothing but the truth, So help me God, so help I Jah. So help me God, so help I Jah. So help me God, So help I Jah Rastafari.
Every time I see the wicked, my belly moves.
You are brought before this court for having ganja in your possession. Guilty or not guilty? Not guilty, Your Honor. How could one man do such a thing? Ganja. It is totally impossible, Your Honor.
I can remember, yeah, when I was framed and chained, brutalized. The grudge would find me guilty for an exhibit they could not find. And every time I see a Babylon, my blood runs cold. I mean cold. And every time I see the wicked man, my belly moves. When I see the condition, yeah, I said it's a curse. For the past 400 years or more, things get from bad to worst. And every time I see Babylon, my blood runs cold. I mean, so cold. And every time I see them wicked, wicked, wicked men, my belly moves. And every time I see Babylon, my blood runs cold. Every time I see wicked men, my belly moves, yo. Every time.
Yes, Famboulin, welcome back. I hope see Monada enjoyed that break day. And the lawyer we at the studio, it's na Paul Kama, we na lecturer na the University of McKinney. They talk about the law of property with particular reference to real property. We na land, house, that kind of thing. Motokasef can be property, not so. Yes, but what we deal with real property, I think that people are interested in this discussion. Yes, so we more can to communal ownership. What is this communal ownership? Probably people in Godoy communal ownership, and people don't know say that nine the way. So what's not communal ownership?
This is one of the wisdom also where you the own property na the provinces. For we grow up upline, you see certain land and I will tell you say this na property this way na field. For example, field, community centers. These are land them way exactly being grown. These are community owned property them. That make anybody who die irrespective of your race, irrespective of your color, and they will bury you. So if a particular investor come, the one can acquire an property there, you need first forget the consent of the chiefdom council, where the head of that's now normally na the paramount chief, if not the chiefdom level, if not the section chief. So this is a system of ownership where involves say you cannot acquire property that is located in the provinces where governed by customary law without having to go through the respective local authorities. For example, the paramount chief, the Edmandem, the section chief, the like people in normal way the community recognize in terms of ownership of land. So if you go this Customary Land Rights Act where they introduce so, it don't clearly define. And this Customary Land Rights Act now don't take away now think you will be get they say the paramount chiefs are custodians of land in the provinces. Now, what a paramount chief? Now paramount chief now just a mere witness. So distinction now don't declare distinction only now as to within a community land, within a individual land, and within a family land. So these are the three forms. So communal are one of the forms where the law recognize as far as the ownership of property concern at the provinces.
But today when it comes to ownership, if you know they call them owners, they call them holders, something of dandy. So what are the reason for dandy?
Some can say release
land holding family. Yeah. You know we say land owning family.
Okay. Well, it depends to the specific wordings we want to use. But the characteristics and basically of communal ownership of land include the shared benefit. All they enjoy if you sell the proceeds same, all they share them equally. The issue of decision making. Not to one person make decision. No, all they take decision. And the property not to one person get them. Now shared ownership. So these are distinctive qualities and way a communal land gets. So in terms of the description, whether they are referred to as holders or owners, for me it's just a use of language where you can basically refer. You can call it also vendors. You can call them different ways and for most of the time where you do conveyance, or if not lease you do, you would refer to them as lessors. If not conveyance you will do, they will refer to them as vendors because they dispose the property in fee simple absolute in possession. So communal ownership, I feel like say in that description it largely depends to the just choice of words in me understanding and thinking.
Okay, so we go to the province. We'll talk about the provinces upline. We say now 3 ways now you the own land there. But in the western area now 1. So what's not the way the own land at the western area?
The western area, yeah, so it's very straightforward. If you own property, you go to the person where own the property. If the family back, you meet the family and then they unanimously agree for dispose of the property. And once they dispose of the property, it can be, they can say, absolute in possession. Feel simple absolute in possession. Now one day they show say they already can acquire this property for the entire term, forever and ever. Amen. And property now one day. And they can normally give an assurance say we don't hold this property for more than a period of this. Now one day now for establish good root of title where you can normally see I'm under the recital clause where they do conveyance. And will tell you the period for which they don't hold this property or they don't acquire this property. Some don't acquire them, can even state them, they can recall them in the conveyance. This family don't get this property for more than 50 years, for more than 100 years, for more than 200 years, for a particular period of time. So once you clearly state now one day, they assure the way they can buy the property, say they can buy the property in the correct hands, and that for be hesitant, and that the interest highly protected. That's not the effect of then clauses in the.
Okay, so you can get, then you say, well, this property you get for due diligence or encumbrance and all that and the. So what's another day?
Well, due diligence basically, as far as property law concerned, these are the respective investigations the way they do. Investigation where you do for ascertain good root of title. If somebody say they sell property, you get for first try for inquire. Now you get this property, how you get this property, how long you don't get this property, from who that you get this property. You also get for go and confirm from independent people. Sunday they go stand small picking and if they go. You go ask that property and who that get them. You go see them because hey na the Kamara family, hey na Pabu, hey na Mr. Wilson. Mr. Wilson ain't gonna property. You ask how long? Hey, we from what them born we. That party na bad. And I would be go play ball. So you done na good na due diligence now one day. You dey try for investigate, for try for protect the interest of the purchaser, for ensure say they go buy from the correct person. Remember, there is a principle of law saying nemo that quad non abet. You cannot give what you don't have. And some people are purporting to be owners of properties when in actual sense not to then get the property. So with good root of title, with due diligence, it able help you for ascertain good root of title, it able help you for ascertain actual ownership, it able help you for even at times even the price. So until we go do due diligence, you cannot say this person where they sell not to even get the property, now an agent, and the original price where they give them, it don't can escalate or skyrocket that price. So it even help you in so many ways when they say due diligence. But this normally now for the interest of the person way they can buy. You also do due diligence for ensure say not to encumbered property. In law, when they say property is encumbered, it means the property get issues. Either na because na state property, or either because na property when na highly disputed or contested property, then na court on a property day, and one person just want come up behind the court and sell, or sometimes the property get injunction. So with due diligence, it will help you for know all the realities here. So.
Okay, so yourself can be part of the program, although not get better time again. By way where yourself will call the phone line open, you can now ask a question to which in we discuss now. So the phone line door open, but we're not going to take plenty calls them because time not too day in favor. Yeah, we'll get the first caller. Caller, you name and which side the call from?
Yes, Ekundayo, the call from Freetown.
Yes. Yes.
I just want know if rural and the law is different from Freetown law as far as land is concerned. If like supposing your land in a rural district and not register them, then if any intrusion takes place, what I for most right to get over that property? That just cut a short for time.
Okay. Thank you for the question. The lawyer did now for answer the question. The line is still open. You can call. Now the number is 077 981 981 077 981 981 and ask a question with regards to the topic we discussed now. Yes, Paul, you don't get from that caller day in question. Okay, we get another question. Another caller again. Caller, your name outside the call from?
Yeah, I call from Cassie. Good evening.
Yes, sir.
Yes, sir. I began an issue with somebody in border, name, I give document, now give me 50 million. So if we left an shop, so in can later, they make confusion in border. They retrieve that document from in border. Yeah, I ask for the document to go to police, they not give me. And I be doing stress. So, you say, Papa, for buy, they didn't give me a caramoni. So, call somebody, they make documents, false documents. So now, you picking them holding at the document.
Hello? Yes, will get you?
Yeah, you picking them now, wouldn't name them at the document. They say they agree for sale. 11 million, 10 million, 6 million, 7 million, not only at the document, so because he left in border at the shop, the same border used the money. We will not transact things in border. That document has been laid in border. What the document? We in Canal, you say on our account, we go police all for making new documents in agree. So it end up for make the only property. Now my yes, sir. I like me, sir.
Okay, later. And the phone line still open. You can call. So the number is 077981981. 077981981. Now the number that where you go call and ask a question. The phone line is still open. Paul has.
Yes. So the first person we call, ask whether who.
Okay, another caller again. Caller, you name who side the call from?
Yeah, I call from Freetown, Mina Concern Citizen. Hello?
Yes, go on. Would they get you?
Yeah. I want to ask something and appeal for something again. Now, the law of upline, let me say, Kono, to be specific, Kono, like how the lawyer said this now, he said, and get something and say, custodian of the land. Like one time, Kono, when me think, say, you know, the north side, where it be say, like, where you don't get your land, you don't acquire your land. Even if where you put something there, for that person who can encroach, you don't put fence or you put pillars around, or you put you build house. Somebody will come, they can't take come. Then when you go for claim your property, they will tell you say go to the chief there. Then go to the chief there. They don't go do anything. Then they go tell you say we know they broke house. So that don't make people and they go and take people and land any kind of way. Because when they take your land, when you go report to the chief, then they say no, we know they broke house na kono. And when you go na court back, then get the way then they do say, but you they fire, you let everything. The appeal when me want do you have me the bed this barrister waiting at the studio? Let them do something. Let them know they come on a corner because if you know go get your land, you don't put pillars there or you don't build some structure there. Then somebody go encroach, it take your land. Then when you go to the chief, they know they say you know better thing. In the end, they go say it's a custodian. So now that, please.
Okay. Okay, caller. We don't get you concerned. Yes.
Yeah. So to the first caller, he make mention of whether there is a difference between the law where they govern the rural and western area. I don't know if now western area urban and western area rural mean, or the rural way it talk about whether or not the provinces. But for the purpose of clarity,
we'll get again another caller. Caller, you name your side the call from.
Hello, I call from Mufis.
Yes, go on.
My name is I just place na jurisdiction. People there, I don't delay my body and make a find someone. They don't go pour the place, up, and pour the place. So right now, I want to know. And the first of the bar to now, Mrs. Bangua, read some Bangua and human.
Okay, well.
I mean, bye.
Okay, well, caller, then they will not go able for deal with them. And I go to your lawyer. I will advise you say may go to your lawyer, may make you deal with that issue there. Okay, thank you. Okay, the line don't close because time not there in favor again.
So, quick one. With respect to accusation of property in the provinces and Western area, I would already say for upline at the Customary Land Rights Act, with the Local Court Act, and the guide how they acquire property under, or how in the event you want for go court, the line of action we for take. And for Freetown, you go straight to the High Court because the High Court gets original jurisdiction. It is the court of first instance as far as title to land concerned. Now to the second caller, that one is largely legal. If you give documents to person, I feel like say if you solicit the service of a lawyer, ask a lawyer, let the lawyer help you, advise you appropriately on waiting for due. And to this last caller, I want to make an clear, say there is no law where say person for going encroach property and if they rely on say now a law they protect them. No, there is no law we provide for that. If you think say somebody don't encroach on the property, meet a lawyer and go advise you waiting for due. I'd already say for title to land at the provinces, now the local court they start time. From there you go to the district appeals court. From there you go to the local appeals division of the High Court. So if somebody take advantage of you, always make a must for go meet a lawyer, let a lawyer advise you appropriately on the line of action. And one thing maybe we want to make clear that as lawyers, we they give general advice on, like then public forum there, so they give general advice on the law, but we not go be very specific to your situation. If you want to follow, be very specific, solicit the service of a lawyer. We have so many lawyers around, very competent lawyers, and we get human rights lawyers as well. Meet them and talk to them. Like for Kono, then get legal aid. If you want, you think you know, maybe personally pay a lawyer, you can go to legal aid, and I know are very certain say the team will they go able to help you on the way forward.
Okay, thank you very, very much, Paul Kamara. We now a private legal practitioner, now also a lecturer na the University of Makeni, and Fambula I know say we don't enjoy, I don't benefit from a knowledge, the thing that we don't talk about, how you acquire property, how you buy land, how you do another western area, how you do another provinces. I know say you don't get knowledge you don't benefit from within you don't talk. Plenty, thank you, Paul Kamara. We joining at this program, Court Ose, and we hope for the bring you in subsequent programs. Then we go to call you for can give you views with regards to the law. Plenty thank you to Theodore Arena. We now introduce the program. Mary Kamara Bangura, we make it live on Facebook. Then DJ Randy, we na the technical man, we behind the machine. Me we present the program. My name Namange Mansari. Stay tuned for another edition. Tuesday from 5 to 6. We'll bring another barrister where he will come explain some other aspects of the law. Until next week, Tuesday 5 to 6, the same time again. My name Namange Mansari.
So help me God.